Hello, everyone. Welcome to today's presentation on the employer's obligations in a green card process for those with DACA. My name is Beata Leah, and I'm a partner at Minsky, McCormick & Halligan, a full-service immigration law firm in Chicago. I've been practicing primarily employment-based immigration since 2007, and I'm presently working on several cases involving DACA recipients being sponsored for their green cards through their employment. As you probably already know, the United States Supreme Court is considering whether to cancel DACA, and a decision is expected this spring or early summer. Unfortunately, many DACA recipients are not aware that they may benefit from an employer-sponsored green card process because immigration nonprofits and most employment-based immigration is not done, I apologize, because nonprofits and most immigration lawyers do not handle employment-based immigration. As a result, many DACA recipients are potentially missing out on a possible path to finally permanently legalizing their status. In my last presentation on January 3rd of this year, 2020, I discussed the three main categories of DACA recipients who may be eligible for an employment-based green card process. The purpose of today's presentation is to go over the employer's obligation in the process so that the DACA recipients can approach their employers to start the conversation. I apologize. And so that the employers can make an informed decision. Please note, however, that what I say today cannot be construed as legal advice and is being provided for information only. I strongly encourage anyone interested in retaining a qualified immigration attorney to carefully review the individual facts of their case to determine if they can benefit from an employment-based green card. But first, let's remind everyone of the three main categories of DACA recipients that may be eligible for an employment-based green card. The immigration laws in the United States make it very difficult for someone who entered the United States unlawfully or who overstayed their visa to apply for a green card, even if they were only a child. As a result, many DACA recipients will be unable to pursue an employment-based green card process in the U.S., but are also unable to pursue the process through a consulate abroad because leaving for the appointment would result in triggering either a 3-year bar or a 10-year bar on readmission. But there are three exceptions, and these individuals should consider asking their employers to sponsor them for a green card. They are, number one, DACA recipients who are eligible for 245I because a family member or employer filed an I-130, I-140, or labor certification for them, their parent, or for their spouse by April 30th, 2001. Or number two, DACA recipients who have not accrued more than 6 months of unlawful presence since turning 18 because unlawful presence begins at the age of 18 and they obtained their DACA before they turned 18 and a half and have maintained their DACA continuously or with short gaps. This also applies to those DACA recipients who last came to the United States in J1, J2, F1, or F2 status and have not changed their status after, with the exception of filing DACA. Or finally, number three, DACA recipients who have a U.S. citizen or permanent resident parent or spouse, making them eligible for an I-601A waiver to waive the 3 or 10-year bar on readmission, opening the door to the possibility of consular processing their case at the U.S. consulate abroad, typically in their country of birth. If you have more questions about these categories, I encourage you to watch the video from January 3rd, 2020, or to reach out to me at 312-427-6163. Now, let's get into the employer's role in this process. The first question that many employers have is whether there are any restrictions on the types of employers or the types of positions that can be used in the employment-based green card process. And in general, the answer is no. Generally, any employer can sponsor a foreign national in any position, but the most common way of getting a green card through employment requires the employer to do a test of the labor market to determine if there are minimally qualified U.S. workers available for that position. This involves doing recruitment for a period of 2 months. If after the recruitment period is over, the employer concludes that no minimally qualified U.S. workers were available, then the first step of the process, the labor certification or PERM application, can be filed to formally initiate the process. Meaning, any employer can pursue the process in any position, but the key question is, how likely is it that the employer will find a minimally qualified U.S. worker during a 2-month recruitment period. The employer knows best how hard it can be to fill a position with a qualified worker. In some cases, it may be hard to fill a position because of the technical nature of the duties or the unique set of requirements needed to fulfill those duties. Other times, it may be hard to fill a position because of the job location or the type of industry or occupation involved. In those cases, if the employer typically has difficulty filling the position, the process is likely to be successful. Now, when doing the recruitment, the employer must follow very strict rules regarding where the ads are placed, for how long, and the exact language used in those ads. Further, there are very strict rules regarding how the employer must review any applications it receives, when it must interview candidates, how it may reject those candidates, and in general, the employer may only reject candidates based on those minimum requirements established for the position at the start of the process. The employer also cannot disqualify any applicants based on subjective criteria or based on criteria that the individual being sponsored also didn't have when he or she started the job. Meaning the employer cannot require anything more than what is actually minimally required, creating requirements that the employee did not satisfy at the time of hire. Now, in addition to agreeing to conduct a labor market test and undergo a 2-month recruitment period, the employer must also agree to use a set wage known as the prevailing wage. This is the wage that the U.S. Department of Labor states is the wage required for the process based on the position's occupation, the job location, and the requirements for the position. Entry-level positions with low requirements have lower prevailing wages than most senior positions with higher requirements. Now, once the Department of Labor certifies the prevailing wage, the employer agrees to use it. This must be used in the recruitment effort, meaning it appears in some of the ads in the recruitment, and must be disclosed to interested applicants if they make it to the interview. Further, the prevailing wage must also be paid to the sponsored DACA employee once they get their green card, but this is typically at least 1 to 2 years later, if not longer. Finally, what are the employer's long-term obligations in this process beyond going through the recruitment period and agreeing to the prevailing wage? Well, the main obligation is this process is that the employer intends to employ the DACA employee in that sponsored position once the DACA employee gets his or her green card. What's hard is knowing when that will be, because honestly, no one can tell you. It's anyone's guess, and processing times change from month to month. Further, the processing time also varies based on the country of birth of the employee and the requirements for the position, which establishes which employment-based category will be used in the process. Put simply, there is a limit on how many employment-based green cards can be issued each year in different categories. And the amount of time it takes to get through the process largely depends on how many people are in line ahead of you. So the timing will also vary depending on whether the employee can complete the process in the United States because they have 245I, or whether they have to do consular processing, which is incredibly unpredictable. So, having said that, the employment-based green card process typically takes at least 1.5 to 2 years, but in many cases can take years more, particularly for those who are born in China or in India, because those countries are very backlogged. Meaning the employer must intend on employing the DACA employee in that sponsored position once the individual gets their green card, but no one knows exactly when that will be. In most cases, the employee will work for the employer throughout the process, so the question of there being a bona fide job opportunity upon getting the green card is not an issue. But it's also possible to pursue a green card based on a future offer of employment, in which case the employer would have to hire the individual years later once they got their green card. So there you have it. The employer's 3 main obligations in this process are: number 1, conduct a mandatory 2-month recruitment exercise to test the labor market and determine if there are minimally qualified U.S. workers available for the position. Number 2, agree to use the approved prevailing wage during the recruitment effort and pay the same prevailing wage to the employee once he or she gets the green card. And number 3, employ the individual in the sponsored position once he or she actually gets her green card. That's it. So what are the next steps? Well, if you have DACA and you think you may be eligible, I recommend taking the following next steps. Compile all of your immigration records and the immigration records for your spouse or your parents. and the information about your entries and exits in and out of the United States, and consult with an immigration attorney to confirm you are eligible. Then, approach your employer to discuss their willingness to sponsor you for a green card, particularly in light of the possibility of DACA being canceled later this year. If you're a valuable employee, they may consider it. Show them this video. If you're an employer with a DACA employee and are worried about losing their work authorization as a result of the Supreme Court decision, don't delay and contact me to discuss whether they may benefit from an employment-based green card. As I already mentioned, the process may take at least 1.5 to 2 years, and we don't know how much time they may have with their DACA. To schedule a consultation with me, you can email me at bleja@mmhpc.com or call me at 312-427-6163. Thank you so much. I sincerely hope that this video has helped at least some of you who probably didn't realize that you may have this other path available to you. Thank you. Bye.